Well, so today we're joined again by the wonderful Rebecca Nagle, who is a Cherokee journalist. We're going to be discussing, I think this is your third time on the show. We're going to be discussing the recent Supreme Court decision that came down in the Castro-Huerta decision. So welcome to the show, Rebecca.
Thanks so much for having me back. I'm excited. I'm excited for this conversation.
So let's talk about Oklahoma v. Castro-Huerta, which was just decided 2 days ago. 2 days ago, at the time of recording, I don't know when this was. Yeah, it was decided on Wednesday. But essentially, this case is in response to the McGirt decision that came down in July of 2020. And I was wondering if you could just give us a brief overview of this decision and how it relates to McGirt.
Yeah, so to back all the way up to the summer of 2020, that July, the Supreme Court ruled that Congress had never disestablished or gotten rid of the reservation of Muskogee Creek Nation. And although the state of Oklahoma had been acting for a very long time, for over 100 years, like it didn't exist, in fact, it still did, because according to our Constitution and the rules that the Supreme Court follows, only Congress can get rid of a reservation. A state cannot get rid of a reservation. And so that came down in July of 2020, and it affected the reservation of Muskogee Creek Nation. And then what followed is that lower courts in Oklahoma affirmed the reservation of 5 other tribes here in the state: my tribe, Cherokee Nation, also Choctaw Nation, Chickasaw Nation, the Seminole Nation, and the Quapaw tribe. As a result, about 43% of the land in the state is now legally recognized as a reservation. Oklahoma immediately started fighting the decision, both through a media campaign and in the courts. And so at first, Oklahoma asked Congress to pass legislation to either disestablish the reservations or just kind of limit the scope of the decision. There was even an idea that the tribes in Oklahoma might be able to cooperate on some legislation. That very, very, very quickly fell apart. And Congress has actually only passed laws to provide resources to the federal government and to the tribes to help prosecute the increased caseload that they saw. And so then, not being able to get what they wanted from Congress, Oklahoma turned back to the Supreme Court, hoping that because the makeup of the Supreme Court had changed and because the McGirt ruling was 5-4, that maybe they could go back to the Supreme Court and get a different answer. So they actually petitioned the Supreme Court over 40 times, asking the Supreme Court to overrule McGirt. The Supreme Court rejected that request, but did take up a case on a narrow question of whether or not Oklahoma has jurisdiction over non-natives who commit crimes against Native people on a reservation. And so it's a little bit complicated, but basically the way that criminal jurisdiction works on a reservation is that states still have jurisdiction over crimes that only involve Native people. So non-Native people. So, when non-Native people do victimless crimes like drug possession, or when the victim is also non-Native, state has jurisdiction. When crimes involve a Native person, either as the defendant or as the victims, tribes and the federal government share jurisdiction depending on the particular crime. And so Oklahoma is trying to add a layer, and they were successful, to that honestly mess of how criminal jurisdiction works on a reservation by saying, but states also have jurisdiction over crimes where the defendant is non-Native and the victim is Native. And so in this particular case, a man, Victor Castro-Huerta, was prosecuted and convicted of child abuse and neglect of his Native stepchild. His sentence was on actually a direct appeal, so his sentence hadn't been finalized. On a direct appeal, his sentence was vacated by Oklahoma's highest court for criminal appeals. The state appealed that decision to the Supreme Court. And on Wednesday, the Supreme Court said, yes, Oklahoma, you retain jurisdiction over this man and over all non-Native defendants who committed crimes against Native people on reservations.
Yeah, this is a pretty historic decision. Not only does it sort of narrow or go after the McGirt decision, but there's larger implications here. And I want to get into some of those later on. But I think it's worth kind of pointing out some of the reasons why this case was brought to the Supreme Court. And Kavanaugh, who's writing the majority opinion for the court, spells out the fact that the Castro-Huerta, his case went to state court and went through sentencing during the McGirt decision, it was during the McGirt decision, and he was sentenced to 35 years in state court. And then he had his sentence vacated after McGirt, and then it was retried in federal court, and he took a plea deal, which basically got his sentence reduced to 7 years. So Kavanaugh points out in his opinion that he got basically 28 years taken off of his sentence. And also the fact that he's a non-citizen of the United States. I think he's a Mexican citizen. So upon the serving of his sentence in prison, he will be deported or removed from the United States. And then the other aspect was that Brett Kavanaugh pointed out that there was 18,000 cases that the state of Oklahoma cited within this case to basically create a sense of urgency around why the Supreme Court needs to weigh in and to essentially rein in or claw back this extension of tribal jurisdiction. Or it wasn't even an extension, it was just the reestablishment of tribal jurisdiction in this area by saying that the transference of 18,000 cases from state court to federal tribal court is creating all kinds of chaos. But on top of that, some people are not even getting sentences, or they're getting reduced sentences, such as the case as Castro-Huerta, which I think is kind of ironic because everyone knows that if you go through a federal system, your sentences are more likely to be heavier than they are to be lighter. I don't know what exactly happened in this particular case. I think it might have been because he was tried by jury in the first one and then got a sentence, and this one he just took a plea deal. I don't know why there's a reduction in sentence, but you wrote with Allison Herrera in The Atlantic that these numbers that the state of Oklahoma has come up with in terms of the 18,000, it's kind of questionable, and we don't really know where they came from. And you both issued kind of Freedom of Information Act requests to get a better idea of what these cases look like. How many were going through, various jurisdictions. But I was wondering if you could talk a little bit about that. Like, where does this number come from, and is it accurate?
The answer is we don't know where the number comes from. There is good reason to suspect that Oklahoma has actually fabricated some of the numbers that it provided to the Supreme Court. And no, it is not accurate. So I want to talk about two numbers Oklahoma put in its briefs. I'm going to start with an older number, which is the number of past convictions that Oklahoma said would be overturned as a result of McGirt. So this is people who were already convicted under Oklahoma state law. Their convictions are old and could get out based on McGirt. And Oklahoma said that up to 76,000 past convictions would be overturned because of McGirt. We asked Oklahoma where they got their number, and they said that they surveyed local district attorneys, and district attorneys provided them the estimate. That's also where they said the number came from in their brief to the Supreme Court. We asked district attorneys through open records requests to just send us the numbers that they themselves had sent to Oklahoma. And the district attorneys didn't know what we were talking about and told us that they had actually not provided the governor's office with that number. And so we actually followed up with the governor's office. We followed up with the lawyer who submitted the brief with this information with them, giving them an opportunity to explain where this number came from. And they declined to comment. It appears to be fabricated, which is a really really serious that we have a state basically making up information that it's giving to the Supreme Court. The other thing that we did is we looked at how many past convictions have actually been overturned. So we looked at how many people have been released from the custody of the state of Oklahoma based on a McGirt appeal. And we got a spreadsheet from the Oklahoma Department of Corrections that covered the first 18 months, which is when most of these cases were brought. And we found that 68 people were released to the street. So 68 people just, weren't retried by the tribes or the federal government. An additional 123 people were released to tribal or federal custody. And then there are 13 people who were successfully overturned one conviction, but are still incarcerated in Oklahoma on other charges, and 4 people who were already on parole or probation. Of the 68 people that have been released because of the McGirt ruling, district attorneys are actually trying to get those people back in prison. Several, as of April, about 8 of them had already actually been back in prison. And so it leaves between the people where district attorneys are trying to do that, or they have been successful or got a court motion, or it's like still under appeal. There are only 33 people, less than 3 dozen people who got off free and clear. So these numbers of thousands and hundreds and all these stories of criminals being set free is just grossly exaggerated. And that's not to say that the impact is nothing, for even, the victims of Jim C. McGirt, the family of George Jacobs, the murder victim in the Patrick Murphy trial, like they've had to re-go through that experience of there being a federal trial, the family of the child that Castro-Huerta neglected and abused. And all of those things are hardships. So it's not to say that the transition and these cases being retried is nothing, but it's not the chaos that Oklahoma exaggerated it to be. And also, there's less than a dozen cases that this Supreme Court decision even stops that process with. Oklahoma courts already ruled that McGirt is not retroactive and it doesn't apply to past convictions. And so there's a handful of non-native defendants who brought this issue up on direct appeal that then Oklahoma appealed all the way to the Supreme Court that are not going to be released because of this decision. It's less than a dozen. So it's ridiculous to think that it has some kind of immediate or large impact on public safety here in Oklahoma. The other thing that Oklahoma claimed is that 18,000 number that you brought up, which is in their briefing and is Kavanaugh's decision. So we asked the Attorney General where that 18,000 number came from, and they refused to give us a source. And so what we did is we asked the District Attorney's Council and the Tulsa District Attorney to give us basically the total number of cases that they filed in 2019, 2020, and 2021. And we looked at how much did those cases fall in the years since the reservation was affirmed, looking at it kind of pre-McGirt and post-McGirt, and also post the subsequent decisions that affirmed other reservations. And we found a 13,000 case gap. So still significant, not 18,000, not what Oklahoma is saying. And then we looked at the increase in prosecutions in tribal court, which was the overwhelming majority of cases, and also the increase in prosecutions in federal court. And we found that it left a gap of less than 1,000 cases. And so if for some reason, some cases are going unprosecuted, it's not the thousands or hundreds that Oklahoma is claiming. And the other thing about what's kind of tricky about that data and extrapolating, well, how much of that is due to McGirt, is that these are the same years that the COVID-19 pandemic really limited how many cases district attorneys were filing. Even the district attorney of Tulsa told us that it would not be accurate to attribute the decrease solely to McGirt, because a lot of the decrease was because of COVID. And so it's just not the chaos that Oklahoma presented to the Supreme Court. And I think it's really irresponsible, but I think it's also really scary that, there was public information out there. Oklahoma was actually asked to defend their data during oral arguments. Our article was actually brought up by Sotomayor in this kind of incredible moment. The lawyer for Oklahoma didn't have an answer for where the data came from. And the majority still based their opinion on it, even though there's really good reason to believe that it's inaccurate and possibly even made up. I mean, it's just extreme how well to see a disinformation campaign, in the local news, kind of on, Channel 6, in the Wall Street Journal, but then to see that same disinformation campaign really hold sway over the Supreme Court in the way that it did is just disturbing.
Yeah, I mean, there's a lot to say about this particular ruling, and I think just having read it twice, I reread the dissenting opinion this morning, and one thing that like really sticks out about this case is, okay, first of all, Kavanaugh, who's writing the majority opinion, states that concurrent jurisdiction from both federal and state governments apply to Indian reservations. He uses very kind of I don't know how to say it, very clear language in how he views state sovereignty in relation to what is known legally as Indian country. And it's also worth, I guess, having reread this, I haven't reread a court case in a while, like a Supreme Court case in a while specifically related to Indian law. But one thing that was really fascinating is the use of the term Indian as well as the use of the term settler, because it just shows like colonialism is like still like a very relevant feature, especially when it relates to Indian law and the usurpation of indigenous authority, political authority, but also the defining of indigenous political authority within federal Indian law, going back to the Marshall Trilogy specifically, and Worcester, the Worcester decision specifically related to, do states have authority in what is termed Indian country? And even going back even further than that, it's like when the United States was founded, it never explicitly authorized states to enter into any relationship with Native nations.
Yeah. And it's not even that it didn't, it made a decision not to. The articles of
there were debates about this.
Yeah. I mean, we were originally organized under, the Articles of Confederation or whatever. And there it was kind of loose. Like it was left up. It was kind of left up to states, and it was open for both federal governments and states to enter into negotiations with tribes. And it was a mess. And so our founding fathers, if we're so dedicated to, what they believed in and what they wrote, and Gorsuch goes into this really well in his opinion, made the explicit decision of like, look, this doesn't work. We have to have it be the role of the federal government to negotiate with tribes. And I think people forget that at the founding of our government, we weren't this country that stretched from sea to shining sea. And in a lot of ways, indigenous nations were still larger than the colonies, still had more military power. And so indigenous nations were foreign governments that, whether it wanted to or not, the United States still had to negotiate with. And of course, that power balance really dramatically shifted, but it's why, federal Indian law looks a lot more like international law than anything domestic. And so just like we wouldn't think that, Oklahoma could go and recognize the state of Palestine or make a peace treaty with Russia, like Oklahoma can't just unilaterally renegotiate its relationship with the tribes within its boundaries. And and so I mean, there's so much in Kavanaugh's decision that is a really, really odd interpretation of the law and statute. And I think my biggest thing of taking it away is, when you read Oklahoma's briefs and when you listened to the oral arguments, Oklahoma was presenting this kind of wackadoodle but very narrow interpretation of the General Crimes Act, they were not asking the Supreme Court to rewrite our foundational understanding of the constitutional relationship between states and tribes. Like, what Kavanaugh wrote was not asked of him, but he went and he did it. And I think what's really terrifying about that is that next term, there is a court case where the lawyers are asking the Supreme Court to rewrite the foundational principles of tribal sovereignty and federal Indian law. And in this Castro decision, the Supreme Court is really signaling that it's ready and willing to do that. And so I think that that is what is scary about the Kavanaugh decision, is knowing about.
Yeah, and Kavanaugh writes explicitly, and I think this to me is the scariest part of this decision. He writes, quote, "To begin with, the Constitution allows a state to exercise jurisdiction in Indian country." Unequivocal, like in his language, right? Obviously, this is with some exceptions. And then he goes on, a quote, "A state has jurisdiction over all its territory, including Indian country." And here he specifically cites the 10th Amendment. And what's important about this, I don't want to read the 10th Amendment. This language is so weird. Like you need some like kind of weird, I don't know, like lens to read it all and to make sense of it. But basically it just says that if the US Constitution doesn't give, whatever federal authority isn't explicit in the Constitution is handed over to the states. That's the interpretation. And how it's been used, how the 10th Amendment has been used, it's the final amendment in the Bill of Rights, so-called Bill of Rights. How it's been used historically has been for a states' rights or a state's sovereignty approach, specifically allowing states to continue the enslavement of African Americans, as well as to continue the segregation and Jim Crow laws, because they have state sovereignty, because it falls outside the purview of federal oversight. There's a growing kind of right wing, not growing, it has existed for a while, to basically see the 10th Amendment as this broad, expansive power, even though it's like one sentence. It's literally like one sentence, and they've interpreted all of these things from it. But nonetheless, while I think the left and progressives have been very critical of the states' rights approach and the right-wing agenda, there's been little attention paid to how that affects tribal sovereignty. And specifically, obviously we can go into the 19th century and look, Gorsuch does this in his dissenting opinion, and look at how specifically the state of Georgia pitted against the Cherokee Nation, resulted in this very violent and genocidal expulsion of the Cherokee Nation and the so-called 5 civilized tribes from the South, and the creation of Indian Territory, which later became Oklahoma. But more recently, and this comes up this didn't get much interrogation within the dissenting opinion or within the majority opinion in this case, was that Public Law 280, the origins and intent of Public Law 280 is specifically about creating equality, quote unquote, under the law, and saying that specifically the people who drafted Public Law 280 and tried to put it into effect were the same senators and Congress people who were arguing for termination, and who had written the termination bills that expressly terminated federal tribes such as the Menominee, for example, and opened up their land for privatization. And since they couldn't do that kind of wholesale to all tribes, they essentially handed over authority to states to pass laws, state laws, to assume jurisdiction. And this played out, this created like a huge back and forth. I'm from South Dakota. It was like the first time that like Native people in that state from Lakota and Dakota tribes like voted en masse as quote unquote citizens of that state. There's like a 90% voter turnout. It's like the highest voter turnout in Native country, to essentially overturn the implementation of Public Law 280, because criminal jurisdiction has always been the back door of termination. It's the first step towards termination, and we've always understood that as Lakota and Dakota people, that state jurisdiction is like like a kind of like a final solution for us.
The way that Kavanaugh wrote about Public Law 280, there's so much in in his opinion, where he's either just completely ignorant or willfully ignoring the facts on the ground and the history. I mean, there's things in there that are actually just factually inaccurate. Like he talks about how like when the general crimes, like in the 1830s, like there wasn't an idea of like tribes within a state because they were separate territories. And it's like, that wasn't us. Like the Georgia's whole thing was that like Cherokee Nation was within the boundaries of Georgia. Like it's just like he's very ignorant. Like it's like I've never read a Supreme Court decision where things were just factually inaccurate as much as this one. But one of the things that he says with Public Law 280 is that he talks about it, but then he makes this conclusion that tribes have no vested interest in states having concurrent jurisdiction over non-native offenders, and that it doesn't infringe on tribal sovereignty. And it also just makes me mad because the whole idea is that, you know, in the quote unquote public safety crisis in Oklahoma is that it's really Native victims that are being harmed. And if you look at PL 280 states, what happens is that everybody passes the buck because nobody actually cares about Native people. And so the state passes the buck and says, oh, well, the tribes or feds can deal with it. The tribes have very limited prosecutorial powers. The feds pass the buck back to the state. It's so much harder for the tribes in PL 280 states to get federal funding for their own courts and their own police systems. It's been a mess. Like,
and it leads to things such as murder, missing Indigenous women, like because of this patchwork of jurisdictions that nobody really wants. I mean, even in the case of termination in our state, in South Dakota, like they realized that, oh man, if we terminate tribes, then they're going to be going to our schools, they're going to be going through our court systems, we're going to have to be investigating these murders, and we don't want to do that. And that's actually why white citizens in South Dakota voted against PL 280 initially, is because they were like, we don't want these natives to be on our dole. And so it's like it's worked in these really strange ways, because in this instance there is a sort of an assertion of sovereignty or jurisdiction in eastern Oklahoma, but it's not like they want to retain that jurisdiction and sovereignty. And I think even Gorsuch points this out, but it's also applicable on the ground. You just ask any kind of court system or jurisdiction that state authorities are less likely to investigate or even care or put as much resources into tribal victims, Native victims who are the victims of crimes by non-natives. That's why we have the Violence Against Women Act. That's why we have all of these things. Even the Indian Child Welfare Act, like that was implemented to protect Native sovereignty, specifically Native victims of crimes by non-Native people, because they skirt those kind of jurisdictional issues. But it's a complete rewriting, because he actually says in this, he says essentially that without concurrent jurisdiction or state jurisdiction, that natives would be quote unquote second class, or they are effectively second class citizens.
And it's BS. It's such BS. And it's, I'm trying as a journalist to be able to document it, but what I'm hearing so far anecdotally, and I have more work to document like a pattern and practice of it, is like already Native citizens are calling 911. And in jurisdictions where the police actually, through agreements with the tribes, do have the authority to respond to that 911 call, they're not, because they're pissed about McGirt. And so the state is already not serving Native victims of crime. We're hearing that from tribal advocates. And so already the word on the ground is that the local law enforcement aren't cooperating to make sure that Native victims still see justice. And so to think that Oklahoma is going to act better now is just ridiculous. I mean, I know I have heard of people calling 911 for a medical emergency and being asked if they are enrolled in a tribe. And so it's just, it's infuriating. And I think what's really scary is, just the crisis of violence in Indian country is a creation of the Supreme Court. It's a creation of the Supreme Court and the 1978 Oliphant decision, which stripped tribes of the jurisdiction to prosecute non-natives. And it has taken decades to partially fix the problem that the Supreme Court created in that 1978 decision. So now, thanks to 2 reauthorizations of the Violence Against Women Act, tribes do have prosecutorial authority over crimes of domestic violence, dating violence, child abuse, sexual assault, kidnapping, actually kind of a long list from the 2022 reauthorization, which was also completely left out of the opinion. That's actually another moment where Kavanaugh is just factually inaccurate. He says, well, the tribes don't have prosecutorial authority over Castro-Huerta anyways. And it's like, actually, with the reauthorization of VAWA in 2022, we do, because we have prosecutorial authority over child abuse now. And so we could have, I mean, not when the crime occurred, but if you are forward looking, if another case like that happened, the tribe would actually be able to prosecute it. So I think it's really frustrating. And I think, you know, in the dissent, Gorsuch talks about a congressional fix. People have been talking about how Oliphant needs a congressional fix. Now we have to go and fix Castro too. And I really think what we need is to like think bigger and just like, look, criminal jurisdiction on reservations, civil jurisdiction too, are both a mess. They're messes that the Supreme Court since the 70s, you know, starting with Oliphant, going through Montana, now this case, the Supreme Court has continued to create the problem and make it worse. And we don't need like a piecemeal fix. We need like a wholesale fix where tribes, we just simply have jurisdiction on our reservations. And so, yeah, I don't know how politically possible that is, but I just think that what we need for safety, if the Supreme Court was really concerned about public safety, which is laughable, it would look at what the decades of research about like the crisis of violence against Native women has shown, which is that the solution to the crisis is tribal sovereignty.
Right. I mean, also the fact that termination is still on the books is still a process. There are tribes that are considered disestablished and have zero jurisdiction or recognition by states. I know of 3 of them in the state of South Dakota. The tribal boundaries are not even listed on state maps because the state refuses to recognize them. And this broad interpretation of state sovereignty over over and above federal, not just federal law, but tribal law, is going to have deleterious implications. I mean, I am thinking about just during the pandemic, for example, when the state of South Dakota saw health checkpoints as an impediment on state highways leading into Indian reservations, they threatened to deploy the National Guard because it was violating the rights of their citizens. And to my mind, you know, historically, the National Guard has never been allowed to go on Indian reservations. They're actually barred by law, by federal law, because they're state authority, their state jurisdiction. And so what's going to prohibit in the future, if there's some kind of conflict between a state sovereignty and tribal sovereignty over the question, you know, of the deployment of state military forces and police? And
I think you're right to be concerned about the broad implications of this decision. I think, you know, the way that it's written, I mean, it's hard to say that it's narrow because it applies to over 300 reservations in the United States, and it's going to reshape how criminal jurisdiction and prosecutions work. So its immediate implications are vast and alarming. But I think what it means for other areas of tribal sovereignty on reservations is really scary. And I think what I am most concerned about is that there is a case that is going to go before the Supreme Court next term called Brackeen v. Holland, in which the lawyers in that case are asking to invalidate and overturn the Indian Child Welfare Act. And they're asking based on 2 arguments. And one of those arguments is a 10th Amendment states' rights claim. That isn't what Oklahoma brought up, but is what Kavanaugh based his opinion on. And really kind of wrote the type of opinion that we could imagine in Brackeen as a worst case scenario. And I don't think people were expecting, like, okay, if we get a loss in Castro, it'll be narrow, you know. I don't think people were expecting this kind of language in this decision. And so I think it's really signaling what's to come. And I think people are in this moment where they're concerned by the authority of the Supreme Court. They're shocked by the decisions that are coming out. It is kind of incredible to like live in a democracy where a decision of 5 people can rewrite, what kind of like autonomy you have over your body or what rights tribes have over our citizens. And I think folks who are watching that really, it's not going to be the kind of blockbuster case that the mainstream media is paying attention to, but we need a lot of people to be paying attention to Brackeen because they're going for the throat. They're going for the guttural. They're trying to gut the foundation of federal Indian law. And, now the Supreme Court, at least, this very slim majority that if it holds together, could do even more damage in Brackeen.
Yeah, and I just want to say one thing about Gorsuch, well, several things about Gorsuch. He's kind of been held up as a, the bearer of, Indian law in this case, but it's like, his readings are very basic. Like I was reading some of these things, and I took a federal Indian criminal law class, and so I understand some of the arguments that he's making, but they're also very narrow. And I think it's important to point out that Gorsuch himself is incredibly reactionary, misogynistic in terms of his rulings. Like he is, he doesn't address the 10th Amendment argument that Kavanaugh puts forward, probably because I assume that he believes in the expansive interpretation of states' rights, but also the fact that like the question of abortion rights for Native women or for Native people in general never kind of crosses the boundary or the threshold of what sovereignty is, because through the Hyde Amendment, it's been banned through Indian Health Services. And it's just really sad to say that like our best champion on the Supreme Court is this reactionary and fundamentally misogynistic character. And that is not a good place to be in. I know some people would disagree with me, but like, I have no faith in that man to successfully arbitrate against something as reactionary as a Brackeen decision.
Yeah, I mean, I think Gorsuch's jurisprudence on tribal sovereignty is like very clear, and I think, and I also think that it's a problem to make a hero or villains out of people because people are more complex. But if we were going to do that with anybody, it should really be Sotomayor. She's like one of the only justices who's consistent. Because even Breyers voted against Cherokee Nation and the father and baby girl. Like Ruth Bader Ginsburg, fucking authored the Sherrill decision, which is like one of the worst Supreme Court decisions for Native rights in the 2000s. Like, I mean, it's hard to find a judge on either side of the aisle. And I think what Gorsuch has done, which I think is like, I tweeted something out after the decision, which is just a simple summary of how tribal sovereignty works at the Supreme Court, which is when tribes win, it's because the court simply applied and followed the law. Right. And when tribes lose, it's because the court made shit up. And so, Kavanaugh cherry picking cases from like the 1890s and cherry picking the language from those cases to say that Worcester v. Georgia, which is still taught in like constitutional law classes as like part of the foundation of federal Indian law, has been overturned, but somehow like every other justice and every like con law professor and every lawyer like missed it, but he saw it. It's just like those, it's a made up kind of new logic that he just kind of pulled out of thin air. And what Gorsuch did in his opinion here and did in his opinion in McGirt is just give a very careful, tight following of the law. And I think what it is with Supreme Court justices who call themselves textualists, who call themselves originalists, is that when it comes to Indigenous rights, when it comes to what's in the treaties, when it comes to even what's in the Constitution about the rights of Indigenous nations, they often chuck those things out the window and just create their own fiction to follow. And so, I think that all justices are complicated. A lot of them have a contradictory record. I think the most important thing to take from both of Gorsuch's opinions, the dissent, obviously, in this one, and then the majority opinion in McGirt, is that he wasn't carving out a new area of federal Indian law. He's not some special advocate for tribal sovereignty like freaking Nina Totenberg describes him as. Like, all these white Supreme Court reporters, are just amazed that Gorsuch is standing up for tribes. And he's actually not doing that much standing up. He's just saying, here is the law. Like, this is what the law says. Here it is. His dissent to me read like a federal Indian law 101 textbook.
Yeah.
Like, you could turn it into like, hey, you don't know much about federal Indian law? Here is an intro. And I think he wrote that because the majority opinion is so wackadoodle and so weird and bizarre and taking things out of context that it almost forced him to say, okay, well, let's start at the beginning and look at the constitutional foundations of tribal sovereignty. It's so obnoxious when white Supreme Court reporters treat that like some novel thing, because it really is like, we should look at it as a bare minimum of Supreme Court justice, A, knowing the law, and then B, applying it to the cases in front of them.
Yeah, if he took my undergrad course, he might get an A for his reporting. And I think just the last thing to point out here, and just to kind of bring it back home, is to show that Kavanaugh explicitly admits that the misinformation campaign put out by the state of Oklahoma had bearing on his decision, which shows, in my opinion, that these justices are not above the law. I mean, not above kind of the social circumstances that the country is, currently embroiled in, or, whatever kind of conditions, but their decisions are being determined by those forces, and showing the extreme undemocratic nature. I mean, Gorsuch even admits this in his dissent. He was like, so the argument goes, 5 unelected judges in Washington now must make the quote unquote right choice for the tribe in terms of jurisdiction. So I think even that kind of that kind of reading of the situation is actually incredibly, it's dire, but it also shows how social forces can influence these institutions. But I think at the end of the day, even Gorsuch's recommendation for legislation, it wasn't actually a recommendation. He said, actually, this doesn't even need to be in the law because it should be understood as such. But if you need to make it clear, then write it clear. But I don't think you actually need to do that. I don't think that the judge or the court's function was to actually be legislative, if you believe in the courts. But since Congress can't pass anything, and since Congress refuses to expand, let alone codify the rights of tribes beyond what has already been written, they've left that up to the judiciary, which is, a crapshoot, and it's loaded dice, to use Gorsuch's, language. It's loaded dice against tribal sovereignty, and that can't be the end all be all of where we're going.
Yeah, when I sat down and I read the dissent this morning, and I've been doing a lot of research about Cherokee Nation in the early 1830s and basically the context that he talks about. He starts off by talking about this famous Supreme Court decision called Worcester v. Georgia, which is considered part of the foundation now of federal Indian law. It's the decision Kavanaugh decided had somehow magically been overturned. And in that moment, Cherokee politicians and advocates went to every branch of the U.S. federal government to try and halt a policy of genocide and ethnic cleansing. They went to the executive branch and President Andrew Jackson, and the policy was eventually carried out by the U.S. military, but it really started with the state of Georgia. And so the state of Georgia formed a special militia, the Georgia Guard, to enforce all these laws on Cherokee land. They had a lottery to give Cherokee land to white citizens. They were defending those white citizens, squatting on Cherokee land. I mean, it was really kind of almost at the level of war. And so to protect their rights, Cherokee Nation first went to Andrew Jackson. Andrew Jackson actually wrote a letter to Congress very similar to Kavanaugh's opinion about how he didn't have the right to interfere with the state of Georgia. And actually, states did have rights over sovereign tribal nations. Cherokees then went to Congress and tried to prevent Congress passing the Indian Removal Act. And in a very narrow margin, by 4 votes, it passed the House and was signed into law. And so the last place that Cherokees went to try and prevent a policy of genocide was the Supreme Court, was, this third branch of our democracy. They won that case. We won Worcester v. Georgia. Georgia's actions in Cherokee Nation harassing Cherokee citizens were declared unconstitutional. And Georgia and Jackson openly defied the Supreme Court and just said, well, we're not going to follow this decision. Mm-hmm. And I think, whatever we think about American democracy, I just think that it's really telling that we're going through these same histories where a state is trying to infringe on tribal sovereignty and tribes are appealing to the laws and the Constitution of the United States, but those roles are reversed to where now, instead of the court being that last bastion defending both the inherent and then the reaffirmed rights of tribes in the U.S. Constitution, the court is the place it's the cutting board. It's the arena where those rights are gutted. And so, yeah, I just think we really have to think about, I tweeted this too, is like, I think that as tribal people, as Indigenous nations, we're the canary in the coal mine. And this isn't the first case where the Supreme Court has invented new rules, new doctrine, and come up with a really bizarre decision. And so as people are now experiencing this, when it comes to EPA, when it comes to Roe, if you'd been following federal Indian law, you would have known the capacity of the Supreme Court to make up its own rules since the 70s. This has been going on for decades. And so I think I think when we think about this moment that we're starting to have a more directed conversation about the weaknesses in our democracy and how those weaknesses that were always there are being exploited in this moment. I think people have a lot to learn from the arena of Indigenous nations and federal Indian law.
Yeah, we're coming up on an hour, but I just a quick response to that. I would say that even having read Gorsuch's opinion, but also having read the debates early on in the Republic, the intention was always a removal. It wasn't. They weren't skirting around that issue or arguing whether or not it was something that was like if it should happen. It was the intent from the very beginning was an expansionist empire. It was just how they constructed the legal arguments to do it became kind of the debates. Some people had different, variations of extreme versions of that. Alexander Hamilton argued explicitly for a strong centralized military, specifically because of the threat and the resources and the manpower of Indigenous nations to check U.S. Power within the Ohio River Valley. That was the intent for the centralized military. Even the question and the debates that led up to the Second Amendment, specifically related to the gutting or the destruction of the Continental Army in the Ohio River Valley. So the amendment was created to essentially arm these large plantations that were outposts to combat Native people through irregular warfare. So and it's not to say that these things were set in stone and that it was, that we were just kind of it was predetermined to be this way, but there were processes set in place from the very beginning. I do think there was a lot of wiggle room, and because of Native resistance and organizing, we did secure a modicum of rights that are worth defending, especially when it comes to the federal relationship of tribes and the United States. But I don't, I hesitate to say, I hesitate to say that it's necessarily our democracy. It's we're part of it, but not by choice oftentimes. And oftentimes we don't have we don't have any democratic means by which to implement our own authority and laws within it. And so there needs to be, I don't know, I mean, it's a whole nother question. We could do a whole nother podcast on it. But I think one thing that history has proven in these cases, like, is that termination has unified tribes historically. I mean, you had the implementation of state criminal jurisdiction on tribal lands in the 50s, and in the 60s you had the Red Power movement, and then in the 70s you have the word sovereignty, because prior to that, sovereignty was not something that tribes used, and now it's become a staple and a weapon and a shield against, overreach from state and federal authority. So I think in some ways we've seen the eroding of our rights, but also I think this might have the effect of unifying tribes against or for something that's much better and more accountable.
Yeah. I think we need, like I said, like a bigger solution than just a Castro fix. And I think we need a bigger solution than just a congressional law. I think again, I think, Indigenous nations are the canaries in the coal mine. And it's like, when you study US law and the treatment of Indigenous peoples, you really see the weaknesses in our democracy, and so that government that carried out, Indian removal after the Worcester v. Georgia decision. And I feel like removal is the sanitized word for when you actually study what happened, because it's so extremely violent. It's really just a policy of ethnic cleansing. Those laws haven't been changed. We haven't gone through a process in our country to fix the foundational, the laws and the parts of our Constitution that not only allowed for, but passed policies of genocide. That's never been fixed. And so I think that, I think that, the structure of Indigenous rights being as precarious as it is, as frightening as it is, about what might happen at the Supreme Court next term, I think we also have to think about further solutions, and that it should never be this precarious. If our Constitution really defended the rights of Indigenous nations, we shouldn't be worried that they would crumble with an opinion written by 5 people,
by an accused rapist. That's the sad part. Anyways, well, thanks so much, Rebecca, for joining the podcast. Check out your Twitter, check out your work. You have 2 podcasts, 2 seasons, and an upcoming season of This Land. So thanks again for joining us.
Thanks so much for having me.